Hello friends, this is Dr. Shashi Agarwal. I welcome you all for the channel Shashi Agarwal Economics and Law classes. Today our subject is business law, and here we are going to understand the complete topic of capacity of parties to contract, or we could say the competency of the parties to enter into contract. First of all, we will understand what is the meaning of competency of parties and what are the effect of minors agreement, and we will also understand the agreement which are done with the person of unsound mind, the agreement which are done with the person who are disqualified by law. If you find my video useful, please do like it, share it, and also subscribe my channel Shashi Agarwal Economics and Law Classes. So this is my app, Adusum app, which you could download from the Google Play Store, and this app provides free study material and free mock test to the student of commerce, economics and management, and business law is also available in the form of structure course. First of all, we will understand what is the meaning of capacity of the parties, or we could say what do you mean by competency of the parties. For a valid contract, the parties who are entering into contract, they should have the capacity to enter into contract, or we could say they're capable of entering into contract, they're competent to enter into contract. Every person is presumed to have the capacity to enter into contract. But there are certain persons whose age, condition, or status render them they are not capable of entering into contract. Section 10 says all agreement they are contract if they are made by the parties who have the capacity to enter into contract. Section 11 of the Contract Act deal with the competency of the party. It says every person who is competent to enter into contract, who should be the age of major according to the law to which he is subject, and he should of sound mind, he should not be disqualified by the law. The following person, they are not capable to enter into contract, they are incompetent to enter into contract: minor, the person who is of sound mind, the person who is disqualified by the law. Section 11 says these persons they are competent to enter into the contract, who is major under law, sound mind, he is not disqualified by the law. Minor is a person who is not a major. According to the Indian Majority Act, minor is a one who has not completed his or her 18th year of age. Section 3 of the Majority Act. So the person who has completed the 18 year is called major, and that person is capable of entering into contract. But if he is not completed, then he is minor, then he is not competent to enter into contract. But in certain situation, the age of 21 year is considered to be the major. Where a guardian of a minor's property has been appointed under the Guardian and Ward Act 1890, or where the supervision or superintendence of minor's property is assumed by a court of ward, here the major age is 21, not 18 years. So why court gives protection to the minor? Minor has an immature mind, cannot think what is good or bad for him. So he cannot make a valid contract. And secondly, law must not cause unnecessary hardship to the person who deal with the minor. Minor has always this logic, this always plea that is minor. So what is the effect of minors agreement, or what are the rules which govern the minors agreement? Agreement which is done with minor or agreement which is done by the minor is void. Section 10 says the party should be competent to enter into contract. Section 11 says that minor is not the person who's capable of enter into contract. So the agreement, whether it is done by the minor or the agreement which are done with the minor, they are void from the very beginning. Void means they are not enforceable by law. They do not have any legal right. The agreement which are done with the minor, they are none. They are non-existent from the very beginning. So it's a famous case, Mohari Vibhu versus Dharmadas. Here A was minor. He borrowed rupees 20,000 from B and executed a mortgage. He became major in few months and he filed a declaration in the court that the mortgage was made during when he was minor, so it should be cancelled. Court decided that the mortgage was void and B could not recover the money from A. Minor could enter into the contract minor on behalf of the minor if like minor can enter into the contract with the help of guardian on behalf of the minor. If guardian enter into the agreement is for the benefit, then it is enforceable. So Shri Kukulam versus Subramanian versus Kura Subbarao. In order to pay off the promissory note and mortgage debt of his father, minor son and mother sold a piece of land to the holder of the promissory note for the satisfaction of the debt. Later, the minor brought the case in the court that it should be declared void, but the court held sale was done by the mother for his son and on his behalf, so it is a valid contract. Agreement which are done with the minor, but they give benefit to the minor, so the minor can enforce those agreements. While no liability can be incurred, but he is not debarred from accepting the benefit. If benefit is given under the agreement, then he can enforce the agreement. If the minor has advanced mortgage money on the mortgage in favor of minor, then he can enforce the contract. In case of Raghav Charyer versus Srinivasa, A mortgaged certain property in favor of B, who was minor. B had paid the mortgage amount to A. Court held that the contract is enforceable. An agreement with minor is completely void. So there is no ratification means no approval. Minor cannot approve the agreement on attaining the majority. Void agreement is always void. So it cannot be ratified. It cannot be approved by the minor becoming the major. Aramgan versus Dura Singha. Minor borrowed a certain sum of money. He executed simple bond for it. After attaining the majority, executed a second bond in respect of the original loan. Here the court declared it void. If one person who was minor, he becomes major. If he makes a new promise for fresh consideration, then it is a binding. But if it is of the old for the old consideration, then it is not binding. Minor can be promissory or beneficiary. If the contract is beneficial to minor, it can be enforced by him. He can go to the court and sue the party. Minor is capable of purchasing a property. He may sue to recover the possession of the property, provided has tendered the amount of purchase money. The General American Insurance Company Limited versus Madanlal Sonulal. X, who was a minor, he insured certain goods with insurance company. The goods were damaged during the transit period. X filed a suit for claim, but the insurance company said, "Okay, you are minor, so you cannot file a case on us." The insurance company took the plea that the person whose behalf the goods were insured was minor, but the court rejected the plea and minor was able to recover the insurance money. No estoppel against a minor. Where a minor, by misrepresenting his age, he has induced the other party to enter into a contract with him. But he cannot be made liable on the contract. So there is no estoppel against the minor. He is not stopped from holding his fancy in order to avoid the contract. The minor has always this plea that is a minor, so agreement with him is void. Court may direct the minor to restore the benefit in certain cases. No doubt minor has got protection, but he is not liberty to cheat others. According to Section 33 of the Specific Relief Act 1963, court will order an equitable consideration for restitution if the minor is still in possession of the money or things purchased out of it. So under Section 33, in certain situation, under Specific Relief Act, the benefit he has to restore back to the party. No specific performance except in certain cases. Specific performance means the contract should be executed as per the original terms and condition. And there is there is no monetary compensation is not a adequate compensation. The court will never direct specific performance of agreement which is done by the minor. But if a contract is entered into by the guardian or manager on minor's behalf and it is for the benefit of the minor, then it could be specific performance can be asked. The contract should be done with the authority of the guardian or manager and it should be for the benefit of the minor. Lalchand versus Nara. Bond was executed by a widow. She was acting as a guardian of her minor son for the payment of her deceased husband's debt. The minor's estate can be held liable for the payment as per the bond. No restitution. Where a contract becomes void if it is not performed by either of the parties. But if benefit is received under such a contract, the benefit has to be given back. Minor is not liable to repay any money or compensation for any benefit, but in certain cases under Section 33 of the Specific Relief Act, he has to restore back the benefit. Minor cannot be declared insolvent even for the necessaries supplied for life. In case the necessities they are supplied to his life, only his property is liable. He is not personally liable. Minor cannot be partner, but he can be admitted to the benefit of partnership where the share in profit is given to him, not a share in loss. Minor can be agent, but he will not be liable to the principal for his act. Minor can draw, deliver, and endorse negotiable instrument without he is not liable. He can draw, deliver, endorse, but he is not liable. In the absence of authority expressed or implied, a minor is not capable of binding his parent or guardian even for the necessary. Parent will be liable only when the minor is acting as an agent. Minor cannot be shareholder or member of the company. If some adult stand for the guarantor of the minority, if the minor does not pay, then the guarantor has to pay. Minor cannot be surety as he is not liable to pay under the contract, but if any adult is becoming the guarantor or guarantor to the minor, then the guarantor is liable. So what are the effect of minor's agreement or rules? Contract by minor. If the contract is made by the minor and adult jointly, then adult only will be liable, not the minor. Minor is liable for the tort. Where a minor borrowed a horse for riding, he is liable when he lent the horse to one of his friends and that horse is injured due to the negligence of his friend and and due to which the horse died, so he is liable for his friend's act. Liable for necessary. Minor is liable for the necessary. He is not personally liable. His property or estate is liable. The term necessary include article which are required to maintain a particular person in the state, degree, and status of life in which uh, which he is accustomed to. In India, food, clothing, shelter, and education have been held for necessary. The whole question turn upon the minor status in life, utility rather than ornament. It means minor, these things should be necessary. It should not be luxury goods. Minor is not personally liable if the necessaries are supplied to him or the person who is dependent on minor. Only the property is liable. There should be two conditions. Contract must be for the goods reasonably necessary for his support or the person who is dependent upon minor and must not have sufficient supply of this necessary. Nash versus Inman. Inman was a minor who was doing his undergraduate degree in Cambridge University. He purchased 11 fancy waistcoats from Nash and he was adequately provided with clothing. So these were not necessary. So Nash could not recover the price from the minor. The following things have been treated as necessary. House given to minor on rent if it is necessary for his living or for the purpose of education. When doctor recommends riding exercise, the horse is lent to the minor. Racing bicycle, but these things they are not covered under necessaries, goods supplied for the purpose of trading, a silver gift goblet, cigar and tobacco, refreshment to undergraduate for entertaining. So we are now clear. The agreement with minor, they are null and void. So now we will understand what is the meaning of sound mind and what are the agreement which are done with the person who are of unsound mind, the person who are disqualified by the law. As per section 11 of the Contract Act, the person they should be competent to enter into contract, they should be of sound mind, they should not be disqualified by law. A valid contract requires assent of two mind because here the two mind they could understand the things in the same way. But a person who's of unsound mind, he will not be able to understand. Unsound mind does not mean weakness of mind or loss of memory, but here unsound mind means lack of capacity to understand the terms and its effect. Section 12 says when we say the person is of sound mind, a person is said to be of sound mind for the purpose of making a contract if at the time when the contract is made he is capable of understanding the terms of it and he could make also logical or rational judgment. A person who is always of unsound mind but sometimes he's of sound mind, then the contract which are made when he was sound mind, they are valid. A person who's always of sound mind but occasionally of unsound mind, so when the contracts they are made during the when he's of unsound mind, so they are void, they are not valid contract. Sandman, the person who is sound of mind, but he's so drunk that he cannot understand the terms of the contract. So he cannot form a rational judgment. So he is incompetent to enter into a contract in the drunken situation. The law presumes that every person is of sound mind unless otherwise it is proved before the court that the person is of sound mind. The court decides whether the person is sound mind or of unsound mind. Unsound mind means the person is lunatic, the person is idiot, the person is the state of drunken or intoxication state. Unsound mindedness may arise from the idiocy, lunacy, drunkenness, hypnotism, and mental decay. Idiot is a person who does not have his brain is not developed, so he cannot think logically or make rational judgment. He is unsound mind by birth. He is incapable of understanding and making rational judgment. His mental power of understanding even ordinary matter are absent. He cannot understand small things because his brain is not developed. So the agreement which are made with idiot, they are void of nature. From the very beginning they are void. So they are not legally enforceable. All agreement except those for necessities of life with idiot are absolutely void. The agreement which are supplied necessary to the person idiot or the person who is dependent upon idiot, here the idiot is not personally liable, his property is liable. He is not personally liable even for the payment of the necessity of life to him, but his property can be used to pay such debt under section 68. Inder Singh versus Parmeshwar Dhari Singh. Property worth rupees 25,000 was agreed to be sold by a person for rupees 7,000. His mother proved that his son was idiot from by birth, so sale was held to be void. Lunatic or insanity, it is the disease of the brain. So here the person loses his reasoning ability because he's having mental strain or mental pressure. But sometimes he could be in the position of saneness, he could be sound mind. If he enter into contract during the period which is of sound mind, then they are valid, otherwise void. So lunatic, agreement with lunatic when he is of unsound mind, void. But when he is lucid, clear-cut sound mind, then it is valid. Drunkard is a person who is under the influence of alcohol or intoxicating substance. He stands the same footing as lunatic. So he cannot make rational judgment. The agreement made with drunkard is void, but ordinary or partial drunkard is not sufficient. He has to prove that he was so intoxicated that he was not able to understand the contract. Then the agreement declared to be void. Hypnotism, it's the temporary incapacity till a person is under the effect of artificial induced sleep. So if he is hypnotized, so the contract made during hypnotism are void. Mental decay on account of the old age, he is not able to understand the terms and conditions of the contract, so void. So unsound mind is of similar to minor. The position of contract with unsound mind, he may enforce a contract for his benefit. His estate is liable for the necessities supplied to him or his dependent. So certain person they are disqualified with the law, alien enemy, foreign sovereigns, insolvent, convicts, corporation and company. Alien is a person who is not Indian citizen. If alien is competent to enter into contract with citizen of India living in India, he can maintain an action to a contract entered by him during peace. Contract entered before the declaration of the war are terminated during the war because they becomes the void if so they are not legally enforceable. Foreign sovereign and their diplomatic staff, they are known as a representative of the foreign states. They are competent to enter into a valid contract, but they enjoy certain special privilege. So they cannot be tried in Indian court unless they voluntarily submit. They can enforce the contract, but an Indian citizen has to get the prior permission of the central government. They can enter contract through agent, and agent they are personally liable. In case of the company is a artificial person which is created by law, so its authority and power and boundaries governed by the Article of Association and Memorandum of Association. If they go behind the power of Memorandum of Association, so those agreements they are void. In case of statutory corporation, it is determined by the statute by which it is established. Act done in excess of these power, they are ultra vire and void. Corporation are artificial person, so they cannot enter into the contract of personal nature. A convict, while undergoing imprisonment, is incapable of entering into contract, but his disability comes to an end on the expiry of the sentence. An insolvent cannot enter into contract as his property lies with the official receiver, or we could say the official assignee. The disqualification of insolvent comes to end when he is discharged, then he can make the valid contract. Otherwise, during insolvency, he cannot make the valid contract. So these are the void agreement.